So, Carl, thank you for opening the floor. Here's the copy.
Okay.
You can read it at leisure. It's almost. Now you all have questions. I certainly have questions. I think that there's still a lot to be learned from Carl Marlinga's experience. So let me turn the floor over to Carl.
Okay. Yes, sir.
Yeah, twice during your talk you mentioned an aversion of appellate courts to hear pleas of innocence after conviction. And then near the end there you said that what was needed are more liberal rules to resolve closed cases. And I was wondering, as a prosecutor, as a defendant, what specifically would you be thinking about in terms of practices or procedures that might lessen that problem?
Okay. First of all, in Michigan, we're talking about Chapter 6.500 of the Michigan Court Rules, normally referred to as the 6500 motion. There are certain things that have been said for so long that it's baked in stone. One is that a court will not be persuaded simply because a witness who testified in favor of the prosecution has now recanted his or her testimony. Just think about that for a second. Okay. They're saying that if somebody comes up and says, that's the guy who held me up and I testified that way at trial, and now I'm very sure that that's not the guy, that's recanting testimony. The reason for the rule has some logic. The reason is that once you put a bad guy away, if the person was really bad, if the person was really violent, he or she goes to prison. There's a community of friends out there who, if the rule were different, if you could have your friends out there go to the witness and say, hey, now Jack's serving a lot of time, you can help come up with the truth over here, all you got to do is recant. There would be a lot of pressure on victims, true victims, who then would have all of this pressure to come in, maybe even threats, maybe bribes. And so the reason for saying that you don't want to look at it has some rationale to it. But to make it this absolute blank statement that we are not persuaded because all that the defense has presented are affidavits from witnesses saying that they're recanting. You find that time and time and time again. Now, just maybe, sometimes that's the actual truth, and so in the DNA cases, when you have the scientific evidence, it very often piles on top of what for years have been attempts by the family of the person who is now in prison to get a new trial or to get a new look at this, and they get affidavit upon affidavit upon affidavit, they get witnesses recant. Well, heck, in the Muldowan case, we had 2 expert witnesses. This was, because you can't tell everything because the story would take as many years as I actually lived it in real life. But it turns out that there were 2 forensic odontologists. The one was Dr. Alan Warnick, who was discredited. The other was Patricia.
Hamill.
Pardon?
Hamill.
Hamill, yeah. And she not only said that, I'm not sure, she filed an affidavit saying, wait a minute, I looked at this stuff and I realized I was dead wrong. Our expert witness recanted and said, not only am I saying I'm not certain that it was Jeffrey Muldowan, I can say now to a scientific certainty that it was somebody else. Now, that's often met with, for instance, there's, in Barry Scheck's book, or maybe somewhere else, I know that there's a story about a person who is accused of, I think it's a rape and murder. These things often go together because that's where DNA evidence comes into play. And now it's shown that the guy who was convicted, that it wasn't his DNA. All right? Suddenly, the district attorney down in Texas comes up with this explanation. That only means he had a co-defendant. Wait a minute! There wasn't a co-defendant mentioned in the whole trial, but now that's the explanation. And they say it with a straight face. They really mean it. They expect you to believe it. That, well, that's the explanation. Not that, well, maybe we got the wrong guy. It's, I will grasp for anything to keep this conviction in place. What makes them think that way? Why is it so onerous to have a second look, to have a retrial? And if you have a number of affidavits of witnesses who are recanting, at some point you pass a critical mass to say, although normally we don't allow recantations to move us, in this case there's enough, or a single affidavit can have such cogent reasons why the recantation is taking place that you ought to look at that. But appellate courts don't. Why don't they? A couple of reasons. First of all, everybody knows the valid reasons why you don't want to reopen these things. Then in addition to that, there's always the statement that, well, this would be very hard on the victims and the families of the victims to never have closure, that these cases can always open up. Well, that is true. However, it's very hard on the wrongfully accused person and the family of the wrongfully accused person. It balances out, but not in the minds of the real far-gone prosecutors or the judges who say that no, I never want to mess with the victim. Once you have the appellation victim, you're lifted above the rest of humanity. You have to be honored. There is nothing that we can do to ever challenge you again, because after all, you were the crime victim. And if you go around talking bad about victims, Judge, you're not going to get elected next time. And Mr. Prosecutor, you're not going to get elected next time. We don't mess with victims. And that attitude permeates the system. That once you successfully establish yourself as a crime victim, you are sacrosanct. You can't be cross-examined. You can't be challenged. You are God's gift to the earth. Now, I'm saying that in a little bit of a sarcastic sense, but it is true that you close your mind. Reason comes to an end, no matter how many affidavits you're going to get, no matter how many lie detector tests are passed. Nobody wants to suggest that maybe the victim was wrong, because that's a mortal sin in today's political criminal justice system. And the Prosecuting Attorneys Association figured this out. It used to be that we represented the people of the state of Michigan. And all of the good literature on the role of prosecutors talk about that the prosecuting attorney is the representative, not of an ordinary advocate to a cause, but the representative of a sovereign whose interest in seeing that justice is done is as powerful as its interest to appear at all. All right? And in those days, in the 30s and 40s, when these statements are made, the criminal justice system was humming along just fine. Now the prosecutors have wrapped themselves around victims and say, oh, no, we don't represent the people of the state of Michigan. We represent crime victims. Well, who can challenge you if you're representing a crime victim, okay? You're automatically always going to be on the good guy's side. You're always going to be on the side of the saints. And that has skewed the system also because, it just does. And so these recantation rules are something. The other reality is that the scientific literature on lie detector tests now shows that they are more highly reliable than anybody has ever been willing to give them credence for. And but now the rules already allow them to be admitted, but so many judges will look at it and not really give it much attention.